So it might seem like it sometimes, but the police can't just arrest you because they feel like it. They need something called probable cause. But what does it actually mean, and how does it affect your constitutional rights? So let's dive deep into probable cause. It's the threshold that police need to arrest anybody for a crime. And it's also the amount of evidence that they need to get a search warrant. So probable cause is defined as reasonable grounds to believe that a crime has been committed and that you're the one that committed the crime. Now, it's higher than reasonable suspicion, which is for traffic stops and stop and frisk law, which we'll get into, but it's much lower than beyond and to the exclusion of every reasonable doubt, which is the standard to convict you in a trial, in a criminal trial. So I like to put numbers on it. Numbers really help people understand where they're at. And I always tell them, I say, when we're looking at probable cause, it can be as low as 40% guilt. Okay. Now, and sometimes when you're arrested, there's overwhelming guilt. But by its definition, probable cause only requires about 40% guilt. That's less than a 50-50 toss-up, and significantly less than beyond a reasonable doubt, which is about 90 to 95%. So let's go into some examples of probable cause. Well, if you smell drugs or see drugs, then that is probable cause. If multiple credible eyewitnesses point to the same suspect and we say, well, we saw her shoot it at him, well, then that can be a factor for probable cause. So when a police officer sees a driver swerving with open containers in the car and then doing the field sobriety exercises poorly, well, that can be probable cause. So there's three specific cases where probable cause really matters. The first one is arrests. Okay, we talked about that. The second one is with search warrants. Okay, the judge needs probable cause to issue them. And the third is defense attorneys can challenge an arrest and challenge pieces of evidence such as the search warrant for a lack of probable cause. And we would file what's called a motion to suppress evidence. And in one of the many ways would be citing to a lack of probable cause. So those are the three most common areas in criminal law where probable cause is being fought about or being discussed. Now, something very important to consider. When we're talking probable cause at 40%, and we're talking beyond and to the exclusion of every reasonable doubt at 95%, well, there's a massive gap in most cases between that probable cause and beyond a reasonable doubt. And a lot of times that's where we step in as expert criminal defense attorneys to step in, attack that gap. Because guess what? If we go to trial, and if the jury thinks that our client is 51% guilty, 60% guilty, 70% guilty. Guess what? That's not 95% guilty. We win. That is not beyond and to the exclusion of every reasonable doubt. It might be probable cause. It might be enough to be arrested and charged with a crime, but it's not enough to be convicted. So in a lot of our cases, one of our main strategies is attacking that gap. So we've all heard the phrase beyond a reasonable doubt in movies and in TV. But what does it really mean in a courtroom and in real life? Now, this is the standard used in criminal trials. And let us know what you're thinking in the comments because we read them all and we love to hear them.